For those who still do not know us, 4IP Council is a non-profit research organisation focused on the link between IP rights and innovation. We commission rigorous independent research on intellectual property, available free of charge. Today there will be a presentation followed by a question and answer on the appeal decision of Unwired Planet v Huawei. You can find a summary of this case as well as of other European case law related to standard essential patents at the 4IP Council website. Please allow me to introduce our exceptional speakers. The Right Honourable Professor Sir Robin Jacob is Chair of Intellectual Property Law at UCL. Before that, he was for many years Lord Justice of Appeal at the Court of Appeal of England and Wales. Sir Robin Jacob sometimes acts as an arbitrator or mediator. Richard Very is a partner in Bird & Bird, specialised in multi-jurisdictional electronics patent litigation with a particular focus on mobile telecommunications patent litigation and arbitration work. He was Vice President and Head of Litigation at Nokia. Both have extensive experience of dealing with IP. Without further delay, Richard, the floor is yours.
So, good afternoon, everybody. Thank you for joining. 2018 was a bit of an exciting year for FRAND. In January and then in March, we had the Shenzhen Court of Appeals court's decision in Huawei and Samsung. And then before the summer, we had the UK court's decisions in Conversant and Huawei and in Apple and Qualcomm. But what was most keenly awaited by all of us, and they certainly kept us waiting, was the UK Court of Appeals decision in Unwired Planet. First of all, we had the rumours that it was going to be out before the summer, and then the summer break came and went, and we got to the October term, and finally in October, David Kitchen and his panel handed down their decision. It largely upheld Mr. Justice Burse's decision, and they confirmed the UK as a good venue which can positively assist parties in resolving their FRAND disputes. I'm going to start by introducing the background, what the facts of the case were, and remind us of what Mr. Justice Burse had decided in the first instance. And then we're going to go on and talk about what was decided in the appeal. So the dispute first arose when Ericsson sold 50 SEP patent families to a patent licensing entity called Unwired Planet. Unwired Planet sold some of those on to Lenovo, and it licensed the rest. And it asserted these patents against Samsung and Huawei. During the course of this dispute, Samsung settled, and it chose its moment very well. It chose its moment when Unwired Planet was cash-strapped, was running out of cash to pay its lawyers, and was on the point of folding. Unwired Planet was being acquired, and as part of the acquisition, it settled with Samsung at what's described in the judgment as a fire sale rate. And its much-needed cash injection then allowed Unwired Planet to continue to pursue Huawei. The first 3 patents came to trial, and 2 of those were found to be valid and infringed, which is a pretty good success rate. The court went on to determine what a FRAND rate would be for Unwired Planet's entire portfolio, and issued what was called a FRAND injunction. This said that if Huawei agreed to pay the amounts that the court had determined to be FRAND, then Huawei would have a license. If it didn't agree to pay that amount, to take that license agreement, then the court would issue an injunction. But because this is the English court and these are English patents, the injunction would be an injunction covering infringement of the 2 infringed SEPs in the UK only. So it's a limited geographic scope of injunction. So that's the key part of this decision. It was that the court, at first instance, had determined what was effectively a global rate for the whole portfolio and backed it with a threat of an injunction in the UK if Huawei didn't accept. Now, there were 4 main points that came out of this first instance decision. The first is that FRAND can be enforced under contract law. The FRAND undertaking is legally enforceable against the implementer as a matter of French law using the ETSI rules. And that's different to some other countries. It's different to Germany, where FRAND has traditionally been enforced as by using the mechanisms of competition law. And why is that interesting? Why is that different? It's because competition law requires you to prove dominance. There's always been an assumption that if you own a standards essential patent, that gives you a dominant market position. But that assumption doesn't always stand up to scrutiny. If for example, your SEP reads on to an option in the standard, and the option doesn't have to be implemented, there are arguments about whether dominance exists. If there are competing standards, we might have arguments about whether dominance exists. By enforcing through contract law, the English court has got around a messy, expensive, and difficult to prove point, and that saves costs and time for the parties.
Actually, there's rather more to it, isn't there? If it's a contract, then the defence is you haven't complied with your contractual terms, and it's a total defence. It's defence to damages, it's defence to everything, it's defence to the whole case. Competition law seems to be taking the view, well, it's a defence to a claim for an injunction. Well, that's not good enough. You want either it's a defence or not a defence. Half a defence is silly. The other important thing, and really, is to ask why have the Germans not really recognised a contractual defence? I think they've made a blunder, frankly. The trouble is that they apply German contract law thinking. German contract law does not recognise the right of a third party for whom a contract is made, whose benefit is made for, to enforce that contract. A contract between A and a B for the benefit of C cannot be enforced by C under German law, which was the rule in English law till 1979, I think. But this contract is not governed by German law. And to some extent it may be because the German courts are thinking in little boxes. They're not thinking in commercial law terms in the way which I think they ought to be. Although it's very little actually in the German cases saying you can't enforce it by contract. It's just that the patent lawyers who are doing it don't seem to realise that they can say there's a contract. Now, I think they're going to wake up and start saying it soon.
Competition law was part of the Unwired Planet case at first instance. And Mr. Justice Burse found that Unwired Planet did hold a dominant position in owning its SEPs. To be fair, that wasn't very argued very hard by Unwired Planet, so it was a finding that almost came about by default. But Mr. Justice Burse went on to find that Unwired Planet had not abused its dominant position. The allegation against Unwired Planet was that it had offered a rate that was higher than Mr. Justice Burse eventually found to be FRAND. But was that an abuse? The answer was no. It hadn't. First of all, it's not an abuse to offer a rate that is higher, so long as this is part of a negotiation. Second allegation made against Unwired Planet was that it had not followed the steps in the Huawei and ZTE case. It had not made an offer to Huawei before beginning litigation, and as a result, the steps that the Court of Justice of the European Union had set out were not followed. Mr. Justice Burse found that the Huawei and ZTE scheme was effectively a safe harbour. Just because you don't follow it doesn't mean you are automatically abusing your dominant position.
Again, I think that is obviously right by an English standard, at least. Some of the discussion of the competition authorities was all about the earlier sort of discussion was all about saying even applying for an injunction is a wicked and evil thing to do. And that, as some will know, it led to various difficulties, not least the idea that going to court and asking for something is something which its competition law can actually touch at all. And I think that somewhat overlooked is the fact that you've got a competition law defence and probably a contract defence, and until that's been heard, no rational court will grant an injunction. And So the issue of a threat of an injunction doesn't really arise until the time comes when the FRAND considerations have already been raised before the court.
The third thing that was decided by Mr. Justice Burse at first instance was the question of jurisdiction. A substantial part of the argument is about whether the English court should determine a FRAND rate globally or should determine a FRAND rate only covering the United Kingdom. Mr. Justice Burse found that where you have two parties, you've got a patent owner with a global SEP portfolio, and you have an implementer that sells globally, then a FRAND license would be a global license. There were a number of arguments against going country by country or having each court only set the FRAND terms for each country, and the main one being that it would require the SEP owner to sue the infringer in every country around the world in order to collect his royalties. And that was quite a threshold. So what Mr. Justice Burse did was, having determined that FRAND in this case was a global license, you could then go on to determine what FRAND terms would be globally. He wasn't treading on the toes of other courts, because the remedy that he was ultimately being asked to grant was an English injunction on an English patent covering the United Kingdom, and that was something that was within the jurisdiction of the English court. So he could go ahead and do that if Huawei refused to take a license on the terms that he had found to be FRAND, and he could do that within the scope of the English court's jurisdiction.
Yes, I mean, that still doesn't solve everything, because it gives a possibility of people applying to different courts in different parts of the world, with courts setting different rates and conflicts between them. A race to the bottom or possibly to the top. And that hasn't yet been resolved, and possibly can't be resolved by courts, which is one of the reasons that probably the way forward in the future may be more towards global arbitration. I'd like also to comment about worldwide rates. Commercially speaking, there are not worldwide rates. Very often the rates are different for different regions of the world. Broadly speaking, there is an Asian rate, which includes China, and a European rate, and maybe a United States rate. And those are the commercially agreed contracts, and the courts could, and I think even within the Burse decision, actually fix different rates for different parts of the world, if that's what people are doing. He didn't do that. He had a lower rate for China, I think, but I don't think it was contested. But I think one could have different rates for different areas of the world, corresponding to the way that actual FRAND licensing works in commercially agreed cases.
So the final aspect of the first instance decision was valuation. Mr. Justice Burse found that theoretically there is only one set of terms which are FRAND in any particular case. And this was one of his more controversial findings, and we're going to come back to it later when it comes to the appeal. He decided that the appropriate way to determine a FRAND royalty is to determine a benchmark rate governed by the value of the patentee's portfolio, and that rate is not going to vary depending on the size of the licensee. So small entrants, according to Mr. Justice Burse, are entitled to exactly the same rate as a large established licensee. He decided that the best way to determine the FRAND rate was to use comparable licenses if those are available. He found that freely negotiated licenses were the best evidence of what rate might be FRAND. Interestingly, one of the rates was determined in an arbitration, and he dismissed that. He said that was not a market rate, that was not a freely negotiated license, it had been determined by an arbitrator. And that again is a point that some people have questioned. But when I spoke to some real estate land lawyers, they said, no, this is perfectly normal when you're valuing rents. You ignore any rents that have been determined by tribunal or set by the court, because those are almost inadmissible expert evidence, and what you're particularly keen on is freely negotiated market rates. So it seems that is at least consistent with other branches of the law. And he did use a top-down approach. We've seen a top-down approach also used in TCL and Ericsson as a primary method, but Mr. Justice Burse found that the top-down approach was most useful as a cross-check, but not a primary valuation method.
Yes, I think he was probably wrong to dismiss arbitration altogether. It depends how the arbitration was determined. You'd have to actually look at the arbitrator's reasons. If the arbitrating had actually used comparables, then it is in effect another court which is trying to assess the same issue of fact as the judge himself. And it seems to me that one would normally, in commercial terms, have regard to such a decision. But it's quite right, in landlord and tenant and things, you don't have regard to other tribunals from time to time. I never quite understood it there. It depends how the tribunal did its work. But it does involve getting slightly more involved. Just one other thing about comparables, they are really important. Of course, the difficulty sometimes is finding a comparable, because you hardly ever find an exact comparable. Many licenses are cross-licenses. Sometimes it has been suggested to me, at least, that some cross-licenses are bogus, but they're there precisely to prevent the thing being used as a comparable.
So we come to the appeal. There were 3 points focused on in the appeal, and interestingly, valuation was not one of them. There was no appeal of the method of valuation, of the use of the comparables, or of the numbers. The points that were appealed were, first of all, was Mr. Justice Burse right to determine FRAND on a global basis, or should he have confined himself to the UK only? The second question is whether non-discrimination should be hard-edged. Now, what's that about? If you remember, there had been an earlier settlement between Unwired Planet and Samsung, and what we know about that is that it was at a very low rate. It was a rate lower than was ultimately awarded for Huawei to pay Unwired Planet by Mr. Justice Burse. And Huawei took the point that that then was a form of discrimination against it. If Samsung had a better rate than Huawei, then was that not of itself a breach of FRAND? Should Huawei not be entitled to the same rate as Samsung, which is one of its biggest competitors? The third point of appeal is whether Unwired Planet had needed to comply with Huawei and ZTE steps, and whether its failure to do so was indeed a breach of competition law. And that came attached to it with a cross-appeal, where Unwired Planet cross-appealed the point about whether it was had a dominant position. So the first point, is a FRAND license a global or a national license? Huawei argued that imposing a global license based on a national finding of infringement was wrong in principle. It thought that this was indirectly a determination of validity of foreign patents. It argued that this offended principles of comity. The Court of Appeal disagreed. It found that it would be wholly impractical for an SEP owner to seek to negotiate a license of its patent rights country by country. And the reality was that patent licensing was conducted on a global basis. It helps that in this case, almost all of the comparable licenses were global licenses. They were comparable licenses to Ericsson's portfolio before Unwired Planet had acquired it, and those were all global licenses. The licenses that Huawei had entered into were all largely global licenses, and the license that Unwired Planet had then entered into Samsung was also a global license. So all of these suggested that FRAND in the industry, the basis was to license on a global basis. The Court of Appeal also looked at a number of other cases that other courts had looked at. The German courts had accepted in a number of cases that FRAND was global. Some of those are listed on the 4IP website if you want to go and have a look at those. The only situation where it hadn't been accepted was by the European Commission in the Motorola case. And that had been largely superseded by the CJEU's decision in Huawei and ZTE. So that was dismissed by the Court of Appeal.
Also, to be fair, that was very early on in the Commission's thinking. And I don't think they fully appreciated just how global this vast network of unfought cases, of global licenses, cross-licenses, and complicated structures, which are all out there, depends on a global appreciation by all parties concerned. And so the court was obviously right to say, well, this early commission decision was wrong. I say wrong, they just didn't pay much attention to it.
Here we come to a point where the Court of Appeal disagreed with Mr. Justice Birse. Mr. Justice Birse had found that for any given set of circumstances, there was one rate that was FRAND. And the reason he found this was that he was confronted with a thing called the Vringo problem, which had come from a previous case of Vringo and ZTE. And this photograph on this slide is of Mr. David Cohen, who was at the time the General Counsel of Vringo. He's also a former colleague of mine, Nokia, and is now therefore universally known as the Vringo problem. The problem is this: if FRAND is a range, and the SEP owner makes an offer at the top of the range, but the licensee is only prepared to pay the rate which is at the bottom of the range, should the court give an injunction, or should it not? Mr. Justice Birse got around the Vringo problem. In other words, FRAND isn't a range at all. There is a correct FRAND rate. The problem is that you don't necessarily have enough evidence to find it exactly. The Court of Appeal, this was fairly heavily criticised, including by US judges, and Judge Robart wrote a fairly stinging rebuke of it. The Court of Appeal disagreed. It found that FRAND might be a range. It applied effectively the willing licensor and willing licensee test, and said that if you've got a willing licensor and licensee negotiating in any particular given set of circumstances, there is a range of outcomes that they could quite reasonably reach between them, and that is FRAND, and it is a range. But the solution to the Vringo problem was solved in favour of the SEP owner. The SEP owner's obligation is to make an offer within the range. If there's a range of possibilities, then the SEP owner gets to choose, and if the implementer doesn't accept, he then risks an injunction. So the Court of Appeal has solved the Vringo problem and solved it in favour of Vringo, although a little late.
Yes, I was surprised by Mr. Justice Birse going for the single rate. It was almost as though he went for the rate as a single rate because that solved the problem, rather than because it was actually a single rate. And I think it's a bit surprising for another ground, that once you've appreciated it's a contract between the patentee and the standard-setting organisation promising to grant a licence on FRAND terms, it follows as night follows day that if he's made a FRAND offer, then he has complied with his contractual duty. And it doesn't matter if the defendant has got another FRAND offer, because he can't complain that there's a breach of the contract. So, I'm quite proud. I wrote this quite some time ago. Contract solves a lot of problems in the FRAND situation.
I think I'm probably the only person left who thinks that maybe Mr. Justice Birse was right, but that's because of my chemistry background, and I'm quite used to the idea of not knowing something and there being a range around it, and knowing that the true answer is somewhere in the middle, if only you had enough data to find it. So maybe the point is academic now, thankfully. The next point that the Court of Appeal came to was whether non-discrimination was hard-edged. Mr. Justice Birse had found that the non-discrimination limb of FRAND is not hard-edged. A licensee may not demand a lower rate than a benchmark fair and reasonable rate just because at some other point another person had been given a lower rate and they were a similarly situated licensee. And the Court of Appeal agreed. It started by noting that differential pricing is not per se objectionable. In other words, it is not an abuse of antitrust and abuse of a dominant position for somebody to offer different pricing to different people per se, unless there are other circumstances, unless it causes some sort of distortion. So if differential pricing per se is not objectionable, the purpose of the non-discrimination problem is, or the purpose of FRAND is to avoid the hold-up problem. And once hold-up has been addressed by ensuring that a license is available on a fair and reasonable rate, then there's no purpose in going further. There's no purpose in preventing the patentee for charging less than the license is worth to some particular owner if it chooses to do so, so long as everybody else is able to get a license at the fair and reasonable rate. Now, it obviously is better for a patent owner if he can always charge everybody the full, fair and reasonable rate. But there are some commercial circumstances, the Court of Appeal recognised, where this might not be possible. And I think they had some sympathy for Unwired Planet. The concept of a fire sale, the concept of a party running out of money and being left in a situation where it either accepts a low rate or folds as a company, it has to accept the low rate. And I think this may be one of these cases of a tough situation creating some sympathy with the court and perhaps creating a law that everybody else has to follow. But the Court of Appeal has come down on the side that non-discrimination is not hard-edged, it's soft-edged.
Yes, I mean, in the real world, not everybody can buy the same product at the same price. If you're a bulk buyer, you can buy things at a lower price than if you're a one-off buyer. And it's not discrimination, it's just a fact of the real world. Another complication about non-discrimination, which they didn't touch upon, and maybe there was no evidence, is the vastly faint and quick-changing nature of patent portfolios and their values. Patents are coming in, or patent applications normally, and patents are dropping out. The nature of the standard keeps changing. They're updated about every 18 months. So if you want to compare a license granted today with a license granted 2 years ago, what is being licensed and what it's being licensed for are different. So it's actually quite I mean, even if you wanted to have a very strict comparison, you're going to come to pieces, and people don't really do that. It is interesting that quite a lot of licenses are on both sides agreed for a relatively short term. They're not agreed for the continuing basis for the life of the patents or anything like that. They're normally sometimes 3 or 4 or 5 years. And both sides are trying to reserve their position, thinking things may have changed in 5 years. One, the patentee may think he's going to have a lot more ICPs by then, and maybe the licensee thinks, no, he won't. There'll be some other guy that have to pay. Who knows?
One of the things that most influenced the Court of Appeal in deciding that FRAND was not hard-edged was the consideration of the negotiation history of the ETSI IPR policy. Back in the 90s, it had been proposed at one point that the ETSI IPR policy would contain a clause that was effectively a most favoured licensee clause, and that was rejected. And the idea that Huawei's interpretation of FRAND as being entirely hard-edged was akin to reinserting that clause in the ETSI IPR policy. And that was one of the points that influenced the Court of Appeal in determining that perhaps this was not the way to go. So the last point of the appeal, does Unwired Planet need to comply with the Huawei and ZTE steps? The problem here, well, there were two problems here. First of all, the Court of Justice of the European Union had not issued its Huawei and ZTE judgment at the time when Unwired Planet was approaching Huawei and at the time when Unwired Planet had started the action. So what Unwired Planet was being judged against was a standard that had been set after it had brought these proceedings. Huawei and ZTE, as we now know, sets out the steps that a patent owner has to take to obtain an injunction under an SEP. And if the patent owner doesn't comply, then he may not obtain an injunction under the rules. But the Court of Appeal found that the Huawei ZTE steps were more of a safe harbour. So, yes, if the SEP owner followed the steps, it couldn't be accused of an antitrust violation, but it didn't follow that being outside the safe harbour was automatically a violation. In Unwired Planet's case, there had been contact between the parties before the proceedings had issued, and at the moment when the proceedings had been issued, Huawei was aware that it was being asked to take a license of the portfolio. It had sufficient notice of the patents that Unwired Planet held, and it knew, or it ought to have known, that a license was required, and it knew that it was being offered a license. So although Unwired Planet may not have strictly followed the Huawei and ZTE steps, the Court of Appeal found
that it was not outside, it was not abusing its position. It also noticed that the German courts had not regarded the Huawei and ZTE steps as being mandatory before commencing litigation in these sorts of cases where the Huawei and ZTE rules had come out during the course of the action. So Pioneer and Acer, Sysfel and Hiaz, St. Lawrence and Vodafone are all examples of cases where the German court had not strictly enforced the Huawei and ZTE steps. So how's the decision been received? This slide, if you can read, has got some quite interesting comments from various people in the media who had commented on it. IAM Media, very positive. The judgment's likely to confirm the UK as a go-to jurisdiction for SEP owners and to secure global FRAND deals. The Telegraph was extremely negative. Huawei faces bill for tens of millions for what the Telegraph described as theft of 4G technology, which is slightly unlike the Telegraph to be quite so forthright and provocative in its statements, but that was a fairly strong comment. Kirkland and Ellis, the UK is now arguably the most attractive forum. Kluver, which is a Dutch blog, it remains to be seen whether the courts of other countries will be prepared to sit back and allow the English courts to play ringmaster on FRAND and SEP issues. So the Dutch are a little negative. Spicy IP is my favourite. This is the Indian patent blog. Perhaps some parts of the judgment seem to be yearning for the good old days of the British legal system and hence the grand assumption of having global jurisdiction, or maybe a colonial hangover that refuses to go away. Slaughter and May and Mishcon are all positive, as is Herbert Smith. And Cartmails wins the banned pun award in its report of the case, which was Many FRANDs Make Light Work. Managing IP is also positive, and IP Drafts was slightly negative. IP Drafts was struck by the number of arguments that they addressed and decided and wondered whether in the interest of efficiency litigation should be reduced to counting the number of arguments that each party makes. But the most telling comment was from Foss Patents, which is normally the most outspoken on many of these SEP cases, and has been completely silent. There are 4 points in the judgment that have been cited by some on the license to all side as supporting the argument that the UK Court of Appeal is suggesting that licenses should be available to all. And I've listed these 4 because I think they're going to get cited in future cases. Paragraph 53, 80, 178 and 196 all contain wording which could be used to say that what Lord Justice Kitchen and his colleagues were saying that a license should be available at all levels of the distribution chain.
Well, they manifestly weren't considering that very important question. I have no idea what the right answer is. I understand there's some litigation in the United States, a judgment by Lucy Coe, and a conflicting judgment from the Eastern District of Texas on RAND. I think it must in the end depend upon the FRAND commitment. And to some extent, the ETSI one, therefore, it depends on French law. There are interesting complications that may or may not arise, and again, I haven't considered this in detail. One is if a chip maker says, well, I want a license to make chips. And the patentee says, well, and let's suppose the agreement means that you have got to grant a license. Can he grant a limited sort of license? And well, you can make the chips, but you can't pass a license on to make devices using the chips. And to that extent, he said, well, look at my patent claims. My patent claims cover not just chips, but devices. And you don't need a license for a device, and I'm not giving you one. And anybody who buys your chips hasn't got one either. And then the counter argument would be, oh, but the license follows as a matter of exhaustion of rights. Well, it might not. I have no idea of the details of all this. I can see lots of lovely arguments to be run by one side or another side. And all I'm doing here is floating out what they are.
So what effect is this decision going to have? Well, one effect that it seems to have had is that it seems to have revived interest in the UK as a venue for SEP cases. And we've had quite a number filed since the Unwired Planet decision came down at first instance. We've got now ongoing Conversant versus Huawei and ZTE, which is a very similar case, with Conversant asserting its portfolio and seeking a portfolio determination against Huawei and ZTE. Apple and Qualcomm. There's been a slight reversal. Apple has asked the English court for a determination as to whether Qualcomm's rates are abusive. That Qualcomm has brought a jurisdiction challenge, and that is working its way through the courts. Philips has brought actions against HTC and Tinno on its standards essential patents in the UK. I assume hoping to take advantage of the portfolio setting and the FRAND setting jurisdiction that the court has now shown that it has. TQ Delta and Zaxel, we are waiting for a judgment on. I'm very much looking forward to seeing what is going to happen in that one. And Nokia and Apple, when they had their patent litigation, shortly after the Unwired Planet first instance decision came down, Nokia seized the opportunity to ask the English court to determine a FRAND rate for its portfolio against Apple. But that case then went on to settle, and so that didn't go any further. And what's the approach of other courts? The German courts, so far, have always said that a German judge can decide whether an offer is or isn't FRAND, but what he can't do is say, in the middle, this is the number that I think is FRAND. And it may be that that is softening. We've started to hear a couple of German judges at conferences suggesting that maybe they could take a more interventionist, a more mediator-like approach. For example, if in a German court you're faced with a patent infringement action and you have one party is saying, I'm the step owner, here's my offer, this is FRAND, and the infringer is saying, well, I think it's a lower amount that is FRAND and I'd be prepared to pay that. The German courts have ordered parties to put forward anonymized comparable licenses and put forward expert reports, which could enable the German court to determine which of the two is closer to being FRAND. And the German judges have suggested in conferences that if they believe that a patentee's offer is close to, but not FRAND, they might advise informally during the course of the hearing. They might say something like, I think your offer is a little too high. I think a lower offer might be considered as FRAND. And then the parties have the opportunity to consider during the hearing whether they want to resubmit a lower offer. And if they can resubmit a lower offer, which the German court thinks is FRAND, and the implementer refuses it, then the German court may go on to give an injunction. Now, that's not, obviously, what Mr. Justice Burse has done, but it is a step closer to resolving the dispute between the two parties. It's not merely answering the question of, is one FRAND, isn't one FRAND. It's bringing the two together and perhaps finding a position in the middle, which is. The Guangdong High Court in China issued a set of SEP guidelines earlier during last year, which suggested that the Guangdong court was also going to have the jurisdiction to determine what FRAND might be. And it went slightly further. It said that it would do so globally, where both parties consented. But if one party objected, and the objection was found to be unreasonable, the court might go ahead and determine the royalties applicable anyway. Now, those guidelines came out in draft. We never saw the final ones, because by the end of last year there was then a big reshuffling of patent cases in China, with all patent case appeals going straight to the Supreme Court. So I'm not quite sure if those guidelines are going to see the light of day again or not, but that shows that China is also considering whether it should adopt a similar jurisdiction or whether it should adopt a position where it can also determine what a global rate is.
And this raises, of course, the possibility of people going to different courts around the world, depending on whether they think they can get a higher rate or a lower rate in which they want. I remain unconvinced that courts are the best tribunals for dealing with this. When I first got interested in this FRAND subject, it seemed to me that it was very similar to fixing copyright royalties and the like. And I sat once as the copyright tribunal with a panel of 5 with different expertises, and that's the important thing, different expertises. And we settled really important rates, like how much the record industry had to pay for records in the United Kingdom when there were such things. And it was a much more interesting way of doing it than courts. And you can see the German courts, their problem is courts are deciding disputes. And it's either one or the other, black and white, whereas this thing is a slightly fudgy sort of thing. So I suspect there may be a greater interest around the world in creating some sort of panel system, global panels, and possibly people from different areas of the world on the panel, so you get some sort of appreciation or feeling of more fairness. And I think it became a stronger need for this because in the era of 5G, we're going to have a lot more licensees who may be paying quite a lot of money, who really aren't very expert in the kind of kit that they're concerned with. I mean, the car manufacturer will just want to buy a box which sticks in the car. It's like a radio. But it'll be the thing that drives the car, or controls the driving of the car. And I doubt they're going to go in for making this kind of kit. And so you're going to have a disparity between the patentees on the one hand and the implementers on the other to a much greater degree than we have now. And that is the consequence of having, I don't know what it's going to be beside cars. I doubt that toasters, which is what the journalists always talk about, why that should ever need to be a 5G toaster. It'd be better to have a 5G bread knife, I suppose. I don't know.
So the next question is what the UK can do to stay ahead and keep itself as a useful jurisdiction for the resolution of patents. The first problem is speed. This case has taken 4 years so far and it's still going, and that's in the context of a 5-year patent license, and that is unrealistic. We've got to find a way to do it quicker and to do it more efficiently. Now, one way to improve speed is if you've got a portfolio where you know that some of the patents are likely to be valid and infringed, you could allow FRAND to go first where that's sensible. So you could first have the FRAND trial, determine what a FRAND rate might be for the portfolio, and if the implementer doesn't agree that the patents are valid and infringed and doesn't take or doesn't want to take a license at that rate, you then go on to the patents trials to determine whether the patents that are being put up are in fact valid and infringed and whether an injunction can follow or not. So that might be one way to improve the speed and improve cost effectiveness. Obviously, it only works where you have a portfolio which is of a reasonable size. If you have somebody with only 2 or 3 patents, then probably it is necessary to put them to proof that some of these patents are valid, infringed, and essential. The second thing we could do is speed the trials up. The trial in Unwired Planet was scheduled to last 13 weeks. The appeal lasted an unusually long amount of time for an appeal. It lasted several days. In arbitrations, we've been doing these in trials where the entire duration of the trial is only 2 to 3 weeks, and that's proved to be possible. In fact, we've found ourselves running short. We've also, in arbitrations, set a rule at the start that the tribunal will hold the hearing within 18 months of the start of the proceedings. And when you consider that most arbitrations you spend the first 4 or 5 months getting the tribunal installed and setting the terms of reference, that means that the actual FRAND dispute in a tribunal, arbitration tribunal, is being determined in a year. And there's no reason why the English court, where the tribunal is already established and where the rules of procedure are already set, there's no reason why an English court shouldn't be able to do these things considerably faster in the course of a year.
That depends on how many judges you've got and what the other lists, the other things that judges have got to decide on, how many, if you're using patent judges in England, whether people are prepared to apply to become patent judges, given that Mr. Grayling took away the judges' pensions if they'd already bought one. So if you become a judge now, you don't get a pension if you've already bought one. Everything that man touched has made things worse.
So the other thing we have to do is reduce cost. Again, arbitration, this action, the costs were above 10 million from the costs award. And that, again, is too high for anything but the largest of SEP disputes. In arbitrations, we've managed to achieve costs to license value ratios of around 2% or less. And that is an interesting guideline. Certainly in litigation, if you can get your costs to 10% of the value in dispute, then you're generally doing well and it's reasonably proportionate. But the main way to reduce cost is speed. If you impose tight deadlines on people, if you keep discovery limited to a reasonable degree, if your discovery is limited to the most relevant comparable licenses and expert evidence is kept reasonably curtailed, again, those are all points that will reduce cost, increase speed. And for lower value licenses, particularly in IoT or where you're dealing with a smaller seller of handsets, there is no reason, I think, why we shouldn't be able to do these sorts of portfolio determination actions much quicker and much cheaper than we've done so far. Now, the next thing we also have to do is improve sophistication of the analysis to the level of arbitrations, which I'll come on to a few measures on the next slide as to how we could do that. And the last thing we've got to do is we've got to overcome our reputation that we have outside globally as the graveyard of patents. And that's a reputation that's hung over from a long time. It's a myth that most English practitioners today think is long outdated. And if you look at some statistics, I hate statistics. They are generally used by lawyers in the same way that the drunk uses the lamppost, more for leaning on than for illumination. But if we have a look back at some statistics, we might see where that reputation came from. Back in 2008-2010, the high-tech patent trials, the UK validity rate was about 7%. By 2011-2014, we're up to 39%, and the time range 2015 to 2018, we're up to 56%. 56% of high-tech patents coming to trial in the UK in this time range have been found to be valid. And that's a big improvement. And if we can get that message out, that the UK is not the graveyard of patents, then we may see more people using the UK for their SEP actions.
Yes, well, I mean, I've seen these statistics. If you think of the logic of this, and I don't know that people are logical, just assume they are for a moment. Most patent actions ought to fail as a matter of logic. Because if you've got a 50-50, both sides are getting the advice that it's 50-50, it's much more in the patentee's interest to sue than it is for defendant to defend. If the patentee sues and wins, he gets his costs, he gets damages, and he gets defendant off the market, and probably others by follow on. But what does the defendant get? He gets permission to carry on doing what he's doing already, and he gets his costs. And so the logic is, if you're running it, is that a patentee with only a 40% chance is probably a reasonable bet to sue. So all over the world this applies. And so and the second thing which I think is quite difficult is the cases. There are some cases where you try it on. I mean, there are some pharma cases, where you crystalline form case with nothing really special about it. It still seems to be worth trying on. Because it's that or nothing. And so people take lower chances. And that may have been the reason for that period where a lot of patents were held no good. I can't think of any cases that were actually wrongly decided, or obviously wrongly decided. Sometimes we reverse in the Court of Appeal, but I don't think much. So these statistics are very dangerous indeed. Lawyers who go around, at one point the Dutch lawyers were about 20 years ago saying, oh, we've got pan-jurisdiction. They were called Rambo lawyers by one of the Dutch judges. And I think that this competition between courts is not a very nice idea anyway.
So moving on to the more sophisticated things that courts can do in these FRAND disputes. The first point is comparable licenses. What Mr. Justice Birss had to do to find the most comparable license was to find one that was close in time, to find the one that was to a similar portfolio, and to find one to a person that was similarly situated. What that meant was eliminating a large number of other comparable licenses and narrowing down the number of data points. The same has happened in TCL and Ericsson, where the court there narrowed down by discarding comparable licenses rather than adjusting them. It would be far better if we could adapt all of the comparable licenses to correct for the changes that have happened. So, for example, the reason why people prefer recent comparable licenses that are closest in time, is because patent portfolios change over time. Patents are granted, patents expire. Also, the weightings between 4G, 3G and 2G change over time. If you go back a few years, then there would have been a much higher weighting on 3G patents, because 3G was the dominant technology and that's what most people wanted, where the value was. More recently, the value has been in 4G. Very shortly, the value is going to be in 5G. So there are changes over time with weightings between people's 4G, 3G and what will be 5G portfolios. There's also changes in weighting between different jurisdictions. If you have a patent owner that holds a patent portfolio that is very US-centric, and you have one infringer that sells much more in the US and another infringer who sells largely outside the US, then you're going to find that those two don't make very comparable licenses. If we can if we can adapt the differences between all of those, then we don't have to discard data points. We can adapt and correct them and use more data points. And the more data points you have on a comparable licenses analysis, the more accurate you are going to be in your result. We're reducing FRAND from this very, very wide range to a much narrower point, and that's going to make a much more accurate process. It might mean that we end up with decisions that are not quite so at odds with each other as Unwired Planet and TCL and Ericsson have been in valuing what was essentially the same portfolio from the same comparable licenses. So that's one thing that we could start to do. The other thing we should start to do is take note of the inherent difference between lump sum and running royalty licenses. Unwired Planet unpacked lump sum licenses to turn them into a running royalty for comparison purposes, but it didn't take any account of the fact that there is a very different risk allocation in a lump sum license to a running royalty license. A lump sum license, much of the risk is with the licensee. He pays a fixed sum, and whether he succeeds or fails is completely up to him. And as a result, there is a very significant discount built into that, and no account has been taken of that so far.
This is not just true of patents, it's true of copyright too. Agreed by the London Symphony Orchestra and what's his name?
Star Wars.
Star Wars, yes. Who played him?
Alec Guinness.
Alec Guinness. Alec Guinness was comfortably off, and he was offered a running royalty or a straight up payment. And he said, I'll take the running royalty. Fantastic dividend. The LSO, short of the ready, would rather take the upfront cash, and they took a fixed rate royalty. You can't turn a fixed rate royalty into a running royalty because they ain't the same thing.
The other thing we could look at is improved metrics for portfolio strength. Unwired Planet was simple patent counting. They compared portfolio strengths by numbers of declared patents. They made some allowances for the fact that not all patents are valid, not all patents are essential, and they applied a suitable reduction to the portfolio to take account of that. But the reduction they applied was by comparison to a sample of patents that had been taken from Samsung's portfolio, and the assumption was that all portfolios would be reduced by a comparable amount. Now that's quite a big assumption, and it's not a very sophisticated way of doing it. So there's a number of things that you could also look at. There are now about 6 third-party essentiality studies that are available on the market. There's Professor Ding's essentiality study that was used in the Unwired Planet case. There's surveys by PA Consulting, iRunway, Article 1, Fairfield, all of which give different indications of how essential various portfolios are in the industry, and those could all be used to weight. There are different ways of comparing portfolios instead of merely counting the patents. For example, contribution counting is a method that has been adopted and put forward by Ericsson in the TCL and Ericsson case. It was rejected in that case, but it was accepted in Huawei and Samsung by the Chinese court. So China is one up on the rest of the world there. Jurisdiction weighting to patent counting is an idea. The idea being that if you have a patent family, and it's granted in a large number of countries, then there's two reasons why that might be more valuable than some of the others. The first is obviously it's covering more jurisdictions. The second is you work on the assumption that patenting organizations within large companies have a fixed and limited budget. They have to decide where they're going to pay renewal fees, and they pay renewal fees in more countries for their more valuable inventions, and their less valuable inventions they allow to lapse in more countries. So if you weight your patent counting by jurisdiction, then you may find that you are applying greater value to the patents that are internally considered to be more valuable. And the final one is citation analysis. Citation analysis requires an awful lot of correction. So, for example, an older patent has had more time to attract more citations, so you have to age normalize. Patents that were first granted in the US attract more citations, so you have to jurisdiction normalize. And there are some companies that have a policy of self-citation, so you have to eliminate self-cites. And once you do that, then perhaps citation analysis is something that we could also be using in courts. We've used it in arbitration so far as a way of waiting for value, and it may be something that should also be considered.
Yeah, I mean, citation analysis has got to be done very carefully. In the olden days, apparently some examiners on a particular subject would have a bunch of patents, which they always cited, partly because they were very well-written patents which set out the state of the prior art. So they used it every time. And it was some of their favourites. Well, you've got to try and build that out. I don't know if anybody's ever done a study finding out whether one examiner does more citation of a particular patent than a corresponding examiner in the same subject. Nice to know.
So we've put up a final slide with the conclusions, and I wondered if there were any questions.
Yes, many thanks for this excellent overview of the Unwired Planet Hawaii case. I will open up the floor to questions. So please do put these in via our chat, which I am just enabling, or you can unmute and ask us directly. We have a few minutes. So whilst we're waiting for questions, I can ask a first one. How influential is this decision on the FRAND debate, and in particular on non-UK courts, in your view?
Obviously, I'm the wrong person to be asking because I'm not a non-UK court. I think quite a lot of courts will say, well, actually, this makes a lot of sense. Do it country by country. Once you grasp that nobody ever does, and you can't, and it's impractical, the logic compels this Court of Appeal decision. So I think probably the logic of the decision, rather than the fact that it's a UK decision, will probably cause other judges to follow the same logic by and large.
I think if it's shown anything, it's shown that it is possible. Up to now, most judges have taken the view that determining FRAND is a commercial matter. That's for the commercial parties to sort out themselves, and a judge's job is to decide whether a patent is infringed and valid. This demonstrates that it is possible for a court to do it, and I think we're going to see many more courts doing it.
Thank you. We have one question for the professor. As you have worked as ADR expert, did you think that the approach of the German court is correct?
I'm not entirely sure what is meant by the approach of the German court. I mean, the German courts have considered lots of different things. Sometimes I agree with them, sometimes I don't. I think some of the decisions, insofar as there was one decision where they said, well, it's irrelevant that the third party can't enforce a contract, is wrong. And I've said that already. I think one of the considerations about the German courts might be that if they're considering comparables, they don't necessarily have sufficient skills by way of procedural skills or abilities to test the evidence and to test how comparable licenses are.
Thank you. And thank you also for joining. I'm afraid we've run out of time for more questions. The slides will indeed be loaded onto our website shortly. And we would also greatly appreciate your feedback on this event, and a brief survey will follow. Please sign up for our regular mailings and watch the website for details of our next webinar. Thank you.